Okay, let's dive straight in. We're looking at a federal court order today that's definitely turning some heads.
Mm-hmm.
A judge basically told a government agency, pretty bluntly, that they've shown a willful and bad faith refusal to comply with discovery obligations.
Wow. Yeah, that's strong language. Instantly makes you think, what's going on there? What are they trying to hide?
Exactly. The case, for anyone following, is Kilmar Armando Abrego Garcia et al. Versus Kristi Noem in her role as Secretary of Homeland Security and others. It's a bit of a mouthful.
Right.
But we're zooming in on this specific court order about discovery. The process of sharing information in a lawsuit.
It sounds like the government wasn't sharing much. The court said the reasons for holding back info just didn't hold water, lacked merit.
That's the core of it.
Hmm.
So what we want to do in this deep dive is unpack that. What were the big arguments? Why was the government objecting? And crucially, what did the court order them to do?
And for you listening, this is, it's a fascinating window into government transparency, or maybe the lack of it sometimes, and how courts step in. It really touches on legal obligations, immigration complexities.
Yeah, how the system is supposed to work, especially when it comes to getting information.
Okay, so where do we start? The false premise. Objection.
Let's start there. The government argued that some requests were based on a, quote, false premise.
Okay, what premise did they think was false?
They claimed the plaintiffs were wrongly assuming the U.S. could be, or had been, ordered to help get Abrego Garcia released from custody over in El Salvador.
Ah, okay, so they're saying that wasn't our job, you can't ask us about it based on that assumption.
Pretty much. But the judge pushed back hard.
Yeah.
Said the real falsehood lies not in any supposed premise, but in their continued mischaracterization of the Supreme Court's order.
Ooh. So the judge is saying, you're the ones twisting things, not the plaintiffs.
Exactly. And the court didn't just say it. They quoted the Supreme Court order directly.
What did it say?
It said the government was properly required to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Facilitate. There it is. So the Supreme Court did use that word. The premise wasn't false at all.
Seems pretty clear, right? Which is why the district court came down so strongly.
Calling it that willful and bad faith refusal.
Yes, and ordering them to give full, factual answers. No more beating around the bush.
That kind of language from a judge, bad faith, that's serious. It suggests they think the government is intentionally playing games with the legal process.
Definitely not a good look. Okay, so that was one major issue. What about the privilege claims? Sounds like they threw a lot of a wall there.
Oh, yeah. They listed a whole bunch. Attorney-client privilege, work product doctrine, deliberative process, even state secrets, and this vague governmental privilege.
Quite the shield they were trying to put up. Right. But here's the kicker, and the court jumped all over this. They didn't provide any backup, no details, no analysis, just the names of the privileges.
So basically we object because privilege. End of story.
Pretty much. And legally, that just doesn't fly. You can't just shout privilege. You have to explain why something is privileged. Show your work, essentially.
Right. You need to connect the dots. Explain how revealing this specific document would harm deliberations or why it counts as attorney-client communication.
Exactly. And you usually need to provide what's called a privilege log.
Can you briefly explain that for anyone not familiar?
Sure. It's basically a list. For every document you're withholding, you list it, say who created it, who received it, the date, what privilege you're claiming, and crucially, a description of the document that gives enough info to assess the claim without revealing the secret stuff itself.
So it forces them to be specific and gives the other side and the court a way to check if the claim is legitimate.
Precisely. It stops parties from just hiding things behind vague assertions. And the court pointed out they'd already warned the government about this.
Ah, so this wasn't the first time.
No. The court mentioned a hearing back on April 16th where they told the government lawyers, look, if you're not answering, you need to specifically claim privilege and follow the rules.
And yet, they still just gave these generic objections,
which the court called boilerplate and non-particularized, and said they were presumptively invalid.
Presumptively invalid, meaning, on its face, it's no good.
And again, called it a willful refusal to comply. The judge was clearly losing patience.
It sounds like it. Did the government offer any solution?
Well, they belatedly offered to meet and confer, basically, talk with the plaintiff's lawyers about maybe creating a log.
Belatedly. after already being told off.
Right, and the court sounded pretty skeptical about whether that offer was actually made in good faith, given everything else.
So what was the outcome on the privilege issue?
A hard deadline, the court said. 6:00 p.m., April 23rd, 2025. You need to supplement your answers, give us the specific legal and factual basis for every privilege claim, and produce a proper privilege log. Or
Nice.
you lose those protections, the privileges are waived. Boof. Gone.
Wow. That's a significant consequence. Basically, put up or shut up and do it by tomorrow evening.
Essentially, yes. Okay, another line of objection from the government involved timing.
Ah, right. They don't want to talk about anything before a certain date.
Exactly. They argued that anything happening before the court's April 4th, 2025 order was outside the scope of this expedited discovery.
Trying to draw a line in the sand. How did the court respond to that?
Not well. They called it an arbitrarily cramped reading of their own order. The judge made it clear that, yes, the period before April 4th is absolutely relevant.
Did they give examples?
They did. They specifically mentioned Abrego Garcia being seized back on March 12th and his transfer and confinement in this place, Secot, in El Salvador. All happened before April 4th.
And that history is relevant. Why?
Because it directly relates to his current status. How can you assess the government's claim that he's solely in El Salvador's custody without knowing how he got there?
Good point.
The court even floated the idea of joint custody or the U.S. having some ongoing control alongside El Salvador. So understanding the history, the transfer, it's crucial to figuring out the present reality.
So trying to limit the timeline was seen as another way to kind of obscure the full picture.
That seems to be the court's perspective, yeah. It's all connected.
Okay, what else did the government object to based on scope?
They also tried to argue that details about Abrego Garcia's removal itself, his initial placement in El Salvador, and his ongoing confinement in Secot were, again, outside the scope of expedited discovery.
So not just the timing, but the core events surrounding his removal and current situation.
Right. And the court fundamentally disagreed. How can we know if the government is doing what the Supreme Court ordered, facilitating his release, handling his case properly, if we don't know the basic facts of his removal and where he is now?
It seems almost foundational, doesn't it?
It really does. The court said this information is central to the whole case.
And they tied it back to that idea of good faith again.
Yes. The court said this information is also relevant to judging whether the government has made, in good faith, all reasonable efforts to comply with the various court orders.
Did they define good faith in this context?
They did, citing a definition, basically the presence of honest intention to effectuate the aim.
Honest intention. So are they genuinely trying to achieve what the court ordered?
That's what the court wants to know, and they pointed out the Supreme Court expected the government to share what it can concerning the steps it has taken. Hiding details about the removal itself seems to go against that expectation.
Okay, so the court overruled most of these broad objections. Did they also rule on specific individual questions, the interrogatories?
They did. Let's run through a few key ones. Interrogatory number 5 asked for the names of everyone involved in removing and confining Abrego Garcia.
And the government's answer?
They gave 2 names. Just 2.
Only 2 people involved in an international removal and detention process. That seems low.
The court thought so too. They called it a deliberate evasion and willful and intentional noncompliance, ordered them to name all involved individuals.
Okay, what about number 7? That was about a conversation.
Yeah, the government's answer was just a conversation happened with a representative.
That's incredibly vague.
Exactly. The court called it vague, evasive, and incomplete, and told them to provide specifics. Who talked, what about, when, etc.
Makes sense. Then there were questions about agreements with El Salvador numbers 9, 10, and 11.
Right. Here, the court actually agreed partially with the government. They said the questions as written were a bit too broad.
Ah, so the government won that point.
Not entirely. The court didn't throw them out. Instead, they told the plaintiffs to narrow the questions, focus specifically on agreements related to Abrego Garcia's removal and anyone removed with him around March 15th. They even mentioned the Alien Enemies Act.
So refine the request, make it more targeted, and that applied to some document requests too.
Yep. RPD's request for production of documents numbers 6, 7, and 8. Same ruling. Plaintiffs need to narrow the scope.
Okay. What about number 12? Efforts to return other wrongfully removed people. Government said that was too much work.
Unduly burdensome was the claim, but the court shot that down fast, said the government made absolutely no showing of why it would be burdensome.
Basically, you didn't prove it's too hard.
Exactly. And the court noted governments usually keep records like that anyway. So answer the question, And that also applied to RPD number 9.
Interrogatory 13. More objections.
Same objections we already discussed: scope, timing, privilege. The court just rejected them again, having already dealt with them, told them to answer it, and also RPD 10.
Right. Now, number 14 was about the MS-13 allegation. That's sensitive.
Very. The government objected, saying the factual basis for claiming Abrego Garcia was MS-13 wasn't relevant or within scope.
But didn't the government itself bring up the MS-13 connection?
Bingo! The court pointed that out, so the government had mentioned his alleged MS-13 membership in updates about potentially returning him. You can't raise it yourself and then refuse to provide the basis for it.
Fair point. So answer the question.
Yeah, answer the question and provide the documents requested in RPD 13.
Okay, last one mentioned here, number 15. Asking for every official with knowledge.
On this one, the court actually sided with the government.
Really?
Found it too broad. Asking for every official who knew anything about all the facts in the complaint, plus those involved in court filings, just too wide-ranging and impractical for expedited discovery.
Okay, so that one got struck down, along with the related document request, RPD 14.
Correct. That request was just asking for too much, too vaguely in the court's view.
So let's quickly summarize the outcome of this order then.
Sure. Long story short, most government objections overruled. The court found they lacked merit, seemed evasive, or weren't properly justified.
Particularly the privilege claims needing proper logs and justification by a strict deadline.
Right. Big deadline there. A few requests about agreements with El Salvador need to be narrowed down by the plaintiffs.
But otherwise, the government has to answer pretty much everything else they were objecting to.
Yes. Answer fully, factually, and promptly, especially regarding the removal, confinement, and the basis for the MS-13 claim. The court is clearly pushing for transparency here.
So when you step back, what's a big picture takeaway from this order? What should people understand?
I think the main thing is seeing the court really assert its authority to ensure the discovery process isn't blocked by, well, what it clearly views as obstructionist tactics.
They're not letting the government just say no without very good, specific, legally sound reasons.
Exactly. The court is demanding adherence to procedure, demanding transparency, pushing back hard against mischaracterizations and vague claims. It's a reminder that the courts are there to oversee this process and ensure fairness, even when dealing with powerful government agencies.
It really makes you wonder, though, why the resistance? What information are they so keen on protecting?
That's the million-dollar question, isn't it? We don't know the answer yet. But the court's actions suggest something significant is being withheld.
And it raises broader questions, too, about government accountability, the balance of power in legal fights like this.
Absolutely. What happens when an individual is up against the resources of the federal government? How does the legal system ensure a level playing field, at least in terms of accessing relevant information? This case is a snapshot of that struggle.
It's definitely a case worth watching. If you want to follow it, the details again are Abrego Garcia v. Noem, civil action number 8.25 CV000951PX in the District of Maryland.
Yeah, seeing what happens next, especially regarding those privilege claims and the deadline, will be very telling.
So the final thought maybe is just how critical this information sharing process discovery really is. It's not just procedural red tape. It's fundamental to getting at the truth and ensuring justice.
Well said. Access to information is often the key to unlocking the courthouse doors in a meaningful way, and this order shows a court determined to keep those doors open.